Hello students, welcome back for the course of MBA semester 3 for Human Relations and Legal Framework. Today is our lecture number 28 and the topic of our today's discussion is the Payment of Wages Act 1936. So, the objective of our today's session is help to understand the Payment of Wages Act 1936 and what provisions has been covered under this act. The contents of today's session are Introduction to Payment of Wages Act 1936, Applicability and Scope of Payment of Wages Act 1936, Important definitions under the Payment of Wages Act 1936, and Responsibility of Payment of Wages. So we are going to start a discussion on this Payment of Wages Act 1936. This is one of the very important act under the labor law, okay, and this Payment of Wages Act 1936 is called as Central Labor Legislation, which was primarily designed to regulate the payment of wages of the laborers, those are working under the different forms of industries and other industrial establishment. So the prime responsibility of implementation of this Payment of Wages Act, okay, 1936 is in the hand of the central government. Simultaneously, the state government will also look after some particular aspects and regulate in states. Okay, this act has been primarily formulated to regulate the payment of wages to the workers employed in certain specified industries and to ensure the speedy and effective remedy to them against the unauthorized deductions or unjustified delay caused in payment of wages to them. Now, what happens in many of the cases, the workers, means the laborers, they are not getting the regular payments, and many of the employers, okay, they are making some unfair justifications by deducting the wages unnecessarily, and that could not be justified to the laborers. So in that case, okay, this act has been empowered the laborers as well as the communities, those who are belonging to the workers specifically. Okay, these workers has been empowered to know their payment of wages, okay, and what will be the total wages that they will receive. Okay, so depending on the various provisions, okay, this act has been primarily formulated to regulate the payment of wages to the workers, okay, and as well as this will provide some speedy and effective remedy against any kind of unauthorized deductions, okay, which has been done by the any kind of employer. If any employer, okay, he has been deducted the wages of the workers, so they can approach to an appropriate authority and make an appeal over there and identify, okay, what are the reasons behind that particular forms of deductions, okay, or why that particular form of delay has been caused to them in case of payment of wages. So this act primarily provide the form of protection in getting the regular payment of wages to them. When we are talking about this Payment of Wages Act, so the central authority would be the central government, and that may be primarily responsible for enforcement of this act in railways, mines, oil field, air transport services, okay, and other related industries. So primarily these industries are in the control of the central government, okay, and all other factories and industrial establishment, those who are being residing in the areas of the state, okay, that for which the state government will take care of. So this act has been primarily implemented by the central government, and then within state, okay, the state government will regulate the activities and identify, okay, whether the payment of wages would be appropriately provided to the working class or not, or any kind of unfair or unauthorized deductions are being there or not. Okay, so in that case, the central and state government will take care of. Applicability and scope of the Payment of Wages Act 1936. When we are talking about to whom that the act has been applicable, the act has been applicable to the whole of India, wherever that act will apply to persons employed in any of the factory or any other industrial establishment, those are residing in India. Okay, so primarily to whom that this act would applied. So this act would apply to the persons employed in any factory or employed upon any other central government organization, say for example railway, okay, either directly or through any subcontractor, okay, or workers those who are working under the contractor that may be covered under this act, or by a person fulfilling a contract with the railway administration, okay, those who are being associated with any railway administration and fulfilling the contract and under which any of the employees are working, or and the persons employed in any other industrial and other establishment, those are being covered under this act. So in general, any kind of workers those who are employed in any factory or industrial establishment or railways or subcontractor, okay, they are being covered under this act. Now what is the primary object of this act? When we are talking about to protect the workers from unfair deductions, so this law has been primarily implemented and to reduce the or to eliminate the malpractices, okay, which are governed by many of the employers. So the main object of the act to eliminate all the malpractices, laying down the time and mode of payment of wages. So this will cover, okay, what is the particular time on which the payment of wages can be made to the workers. So on completion of the month, okay, whatever the wages of workers should be paid to that particular worker, and the mode of payment of wages, okay, particularly that payment of wages can be made available to the workers, okay, whatever sum would be there, okay, in total, and what shall be covered under the payment of wages, okay, we will have the definition of wages, okay, that we will see right now, that are covered in the payment of wages, and all other perks and benefit will not be covered under the payment of wages. As well as securing the workers are paid their wages at regular intervals, it is quite necessary that the act will be implemented to identify whether the employer has been paid the wages on regular intervals, means on completion of every month without any unauthorized deductions. So this is one of the very important clause over here. So here the employer, suppose he has made any kind of deductions over there, okay, they need to specify, okay, what form of deductions that they were made from their regular wages. This act has been primarily empower the central government as well as state government to enhance the ceiling by notification. Okay, now what will be the amount of wages that should be paid to the individual workers those who are employed in industries and other industrial establishment? The central government will time to time they will increase the ceiling, okay, by means of using their notification, and the act has been extended to the whole of India. Now when we are talking about what should be the minimum wages that employer should have to provide to the workers, so this act will applies to the wages applicable to the employed person in respect of wage period if such wages for the wage period do not exceed 6500 per month or such other higher sum on the basis of figure of consumer expenditure survey which is published by the National Sample Survey Organization. So there is one organization in India, okay, that is called as National Sample Survey Organization. They are conducting the consumer expenditure survey every year. Okay, on the basis of that, okay, the central government will notified. So on every 5 years, such kind of data has been collected and identify whether it will be an increase or decrease to be there, particularly increase, okay, with respect to the uh, wages of workers. So this act could be applicable to the employed person who are drawing the wages, okay, which is not exceeding rupees 6500 rupees per month, okay, for that particular wage period. So uh, the act could be applicable to all such workers those are drawing the wages, okay, which are not exceeding 6500 rupees per month. Now the provision has been increased so far, okay, and every 5 years this ceiling has been defined, okay, according to the official gazette of the central government. Now there are different definitions. I have been covered some important definitions under the Payment of Wages Act 1936. So the first definition is called as factory. So factory means any kind of factory which has been registered under the Factories Act 1948. Okay. So it is a place of employment where the workers has been working and registered under the Factories Act 1948. Okay, as well as this factory will also cover some other industrial and other establishment. Okay, this law has also made the provision and covered some particular type of factories, those and under which whatever number of workers has been covered over there, okay, that workers are getting that payment of wages appropriately or not, the act would be applicable to all such factories and other industrial and other establishment. So this act will cover some other industrial establishment, okay, where there is a tramway service, okay, or motor transport service would be there, air transport service, okay, those who are belonging to the civil aviation forces. Okay, the act would not directly cover to the military, naval and other air forces. Okay, uh, uh, industrial establishment also include dock, okay, wharf and jetty, particularly on which the loading and unloading of the shipment will happen. Okay, inland vessels and mechanically propelled devices, okay, wherever they it has been in operations. Okay, mines, quarry and oil field, wherever the workers has been working in mines, quarry or oil field. Plantation, okay, workers those are belonging to workshop and other establishment where they are producing some particular items, okay, or they will be in use of transport or sale. So any workers those who are working on any transport services or those who are in manufacturing processes or any sale, okay, they are covered under this act. Establishment in which any other work relating to, okay, if any other kind of industrial establishment wherever construction work goes over, okay, or development of maintenance building road bridges canals or any other operation connected with navigation irrigation and supply of water relating to the generation and transmission and distribution of electricity. So workers belonging to these industries, okay, they are being also covered under this factory, okay, which has been covered under the Factories Act 1948. So any type of workers, those who are those who are working under factory, okay, and registered under the Factories Act 1948, okay, the act could be the Payment of Wages Act could be applicable to them. Now the another definition is called as wages. Wages means the total remuneration received by the worker, okay, by the employer. Okay, This does not include the any kind of other perks. Okay, this will include the salary and other related allowances, okay, which has been expressed or implied. Okay, and this will mention that what should be included in wages. So wages in general means what, any kind of or total remuneration. This will call as what, all remuneration received by the worker by the employer. Okay, so there are different clauses under which the wages has been mentioned. Okay, according to the some particular. So the first one is any remuneration payable under any award or settlement between the parties. So any kind of payment, okay, uh, which has been made by the employer or by the party, okay, as a form of settlement, okay, that should be termed as remuneration, and in general it is called as wages. Any other form of remuneration in which person employed is entitled in respect of overtime work or holidays or any leave period. So any kind of remuneration, okay, received on the behalf of any kind of overtime he has made, okay, or any holiday related work he has performed, okay, so he will receive the remuneration, and that will be covered under wages. Any additional remuneration, okay, that should be also called as wages, okay, which has been covered under this act. That additional remuneration will be called as bonus. So bonus will be the form of additional remuneration that is covered under this payment of wages act. Any form of sum, okay, or any sum which by the reason of termination of employment of person employed is payable under any law, contract or instrument if the employer has terminated the employment or services of the employee, okay, on account of termination, okay, the employer shall have to liable to pay, okay, the total wages of that particular month, okay, that remuneration is nothing but the form of sum that the worker will receive, and that will be called as what, wages, okay, which has received on due to the reason of termination of the employment, which this will also provide the payment of such sum whether or without deductions, but does not provide the time within the payment is to be made, or any other sum which the person employed is entitled under any scheme framed under any law or the time being in force. Now there has been some particular cause with respect to the time of payment of wages. So on what account of time the wages has been paid, okay, this is not clearly mentioned, but this will include any kind of sum the person, those who are being employed in the industry, so that will be treated as wages. Now there are some aspects that are being related with the remuneration, but it is exactly not a remuneration which can be made to the employee, okay. So this will not be included in defining the wages. So indirectly, okay, any form of bonuses, okay, bonuses would be generally treated as a scheme of profit sharing, okay, that will boost up the morale of the employee. So bonuses would not be directly covered under the wages, okay, that are excluded. Any form of value of any house accommodation, supply of light, water, medical attendance, or any other amenity of service excluded from the computation of wages. So any worker, those who are receiving HRA, okay, some sort of expenses, say for example electricity expenses, water expenses, medical expenses, which has been covered in wages, but it is not directly comes under defined definition of wages. Any contribution paid by the employer to pension or provident fund, okay, pension and provident fund could not be directly contribute, or its interest could not be contribute in defining the wages, okay, under the payment of wages act. Any traveling allowances received by that particular employee will not be also does not constitute the part of wages. Any sum to the employed person to defray special expenses entitled on him by the nature of his employment. If any particular special expenses, if any of the employees, those who are entitled to get, that will also not being covered under the payment of wages while defining the wages, or any other sum, okay, that will be called as gratuity. Okay, gratuity payable on the basis of termination of the employment, okay, that should not be also treated as wages of that particular employee for that particular month. So these are the conditions, okay, what should be the wages, okay, and what should not be the wages. So wages does not include bonuses, any kind of allowances specifically which are relating to HRA, okay, or other expenses, okay, contribution paid by the employer, say for example pension or provident fund, any traveling allowances, okay, any kind of special expenses, and gratuity payable on the termination, that will not be treated as wages under the payment of wages. So this will specifically works in defining the payment of wages, that is called as remuneration or total remuneration that the individual workers, those who will be received after completion of the every month by the employer. Then responsibility of the payment of wages. Now whenever the employees, means the workers, are employed in the factories or any industrial establishment, it is the duty and responsibility of the every employer to make the payment of wages on completion of each and every month, okay, and that wages has been calculated by using an appropriate method and should be provided to that particular workers, those who are being entitled and covered under the payment of wages act accordingly. And there will not be any undue deductions over there. So appropriate treatment would be mentioned, would be given over there, and whatever deductions are supposed to be there, that should be clearly mentioned. In case of Factories Act 1948, okay, there are some person, those who act as an employer over here, okay, that employer would be liable to pay the payment of wages to the workers. Now who will be called as the that particular person, those who are being entitled to make the payment to the workers over here, okay, according to the payment of wages. So according to Factories Act 1948, okay, the manager of the factory, okay, they need to provide the payment to the workers, and those are being covered in clause F of the section 1 and section 7 of Factories Act 1948. Okay, so all managers here can be treated as an employer. Okay, so in any industrial establishment or other establishment, if the person responsible to the employer, okay, for supervision and control of industrial and other establishment, so any person working directly under the employer, and they are primarily having a responsibility of supervision and control, so they will be also treated as indirectly as an employer, and they will be liable to make the payment of wages to the workers. In another case, say for example railways, okay, other than factories, specifically this law has been covered the railway employees. So if the employer is the railway administration, and the railway administration has nominated a person in his behalf for the local area concerned, okay, so on in this railway department, okay, the railway department will nominate some particular person, say for example maybe the manager over there, okay, that manager will be act as a employer of the railway administration, and they will be liable to make the payment of wages to the workers, those are working in this railway department. Now there are some special cases, contractors, those who are being working directly under the charge of the employer, okay, that should be also covered as a part of the employer, and they will be liable to make the payment to the workers. Even person designated as maybe subcontractors or contractors, okay, those are directly working under the employer or principal employer, okay, they will be treated as an employer, and they need to pay the wages regularly without any deductions to the employees. And in other cases, any person designated by employer as a person responsible for complying with the provision of the act, person so named, or a person responsible to the employer, or person so nominated, or person so designated, as the case may be. Now in case of any kind of principal employer, okay, in general we will call as employer. Okay, the employer can nominate any particular person who can make or disburse the payment of wages, okay, to the particular group of employees, those who are working under the factories, okay, those who can disburse the payment to the workers. So that person will be treated as an employer in this case. It shall be the responsibility of the employer to make the payment of all wages required to be made under this act. In case of contractor or person designated by the employer fails to make such payment, okay, now it shall be the duty of that employer or the contractor, okay, those who are directly or indirectly associating any kind of supervisory task and under which the employees are working, okay, that employees need to pay the regular wages on completion of every month, okay. So that clause would be covered over here, okay, and that is the responsibility of each and every employer over here. So that's all about our today's session. We will discuss the remaining part in the further session. Thank you very much.